We will start. We will start momentarily. We're just awaiting our third panelist, Aisha Amjad. So thank you for your patience, and we're really glad that you're all here. We have an amazing turnout this afternoon. And the weather in Toronto is reasonably lovely, actually. The sun is out, and the temperature is also quite nice. And Timothy, how is the weather in Chicago?
It's cold and it's gray.
Really?
Yes.
Don't you wish you were back here in Toronto then?
No, I come back. I come back with great frequency and always with a sense of relief. But our path, where our path leads, is not always a matter of our own preferences.
Of course, totally understandable. So Aisha has joined us. Welcome, Aisha. You can, I think we have to allow Aisha to show her video or start her video.
There we go.
Yes, Assalamu alaikum. How are you, Aisha?
I'm good. Walaikum salam. How are you?
Alhamdulillah, very well. So I think we're all here now, that all the people that need to be here at the beginning of the seminar. So I'd like to welcome you all. My name is Nuzhat Jaffrey. I'm the Executive Director of the Canadian Council of Muslim Women. What we're going to do this afternoon is just give you a very brief introduction to the project or the program that this seminar is a part of, and I'll give you some background information about our involvement with family law over the last few decades. And then we'll get right into the panel. I know that's going to be a very stimulating conversation. And of course, unfortunately, we won't have time to unpack everything and discuss everything that everyone would want to discuss, but we've sort of structured it around certain topics. And then hopefully the audience will have a chance to ask questions as well. If you do have questions, please use the Q&A symbol at the bottom and type in your questions there. And then at the end of the seminar, or the panel discussion, Sabrine will join us and moderate the Q&A that is received from anyone who's in the audience who wants to ask questions of our panelists. So I think we can move to the next slide, please. So I think, Sabrine, you're going to provide some background to this seminar.
Yes, of course. So I do want to thank you all for joining us today. I'm just going to pause this very briefly as Iman will be taking over the PowerPoint. Thank you, Iman, for doing so. Can everyone see the screen okay?
Yes, we can. And someone's saying that it's hard to hear you, Sabrine. So maybe you can get closer.
Okay.
Or use earbuds or something.
Okay, can everybody hear me a little better now?
Mm-hmm.
Yes, we can.
Incredible, thank you. So I do want to thank each of you for joining us today. I do want to mention very briefly for the legal professionals in the room, those who are seeking accreditation, we are seeking it on our end. And once we receive it, we will email each of you individually. So this seminar is in partnership with quite a few organizations. We've developed it as part of this year's Access to Justice Week. And the aim really is to work with lawyers and community workers so that we may all better equip ourselves to provide supports and services to Canadian Muslim women seeking family law counsel. So this is part of a pilot program that CCMW has initiated about 2 years ago. It's called the Legal Services Coordination Pilot Program. I am the Legal Services Coordinator here at CCMW, and it's the first ever Legal Services Coordination Pilot Program geared specifically to Muslim women in Canada. So the program aims to provide culturally appropriate legal services coordination for Muslim women across Canada seeking family law counsel. We work with a variety of lawyers, mediators, and social service providers to support Canadian Muslim Women Seeking Family Law Counsel. And we'll get into that in a little more detail later. For lawyers who are looking to join our roster, we will make mention of that later on in the program.
Thank you. So next slide, please. Some folks are saying that they're having trouble hearing. I'm not sure why, but they're saying they're not getting any audio. So it might have something to do with the settings. Iman, if you could just follow up with those individuals, that would be great. So I'm going to take you through our journey on family law at CCMW very briefly, because we want to really get into the discussions with our panelists. So our work in family law really began with a rumor back in the early 2000s that there was a gentleman who wanted to establish a Sharia tribunal in Ontario. And, we did a lot of research. Where is this coming from? Who is this person? What does it mean? We did a lot of groundwork. We did policy work. We looked at what other jurisdictions were doing, what it would mean. But essentially, this particular lawyer had said that they were going to use the Arbitration Act in Ontario to establish a tribunal. And, we were approached by the media actually saying, do you know anything about this? What does it mean? So we said, we don't really know much about it, but we want to study this issue. So we did, and we looked at the legal ramifications of having, binding arbitration decisions that were going to be made by leaders in the community or imams or other individuals who may or may not have legal training either in Islamic jurisprudence or in family law in Canada, but yet they were going to be able to make these decisions. So lo and behold, we actually campaigned with many other women's organizations, and Barbara is actually with us who was there. We had different faith communities join our campaign. And the Ontario government decided, after a lot of pressure from communities and from women's organizations and so on, that they would have no religious arbitration, that religious arbitration would not be allowed in Ontario, and actually it isn't in, I think, any other Canadian jurisdiction either. So after that, we thought that it was very important for Canadian Muslim women to know what their legal rights were, and also how you navigate or compare Muslim and Canadian family laws. So we had an incredible, research project to actually to prepare a comparative primer. And that was done by a legal scholar and champion of women's rights and family law practitioner, Pam Cross, and an Islamic scholar who's at Concordia, Professor Linda Clark. So based on that, we published materials that were published in many different languages, Muslim majority languages, and then distributed them to community service agencies, mosques, and so on. So that was a while ago. I mean, that was almost 15 years back. So, and then there were many, many changes that occurred to family law, especially in Ontario, and probably similar changes occurred in other parts of Canada. And we thought it was time to update the information based on all the changes that had happened. So then we published, we revised the booklets to reflect changes in family law. And we also try to scan jurisdictional differences, and then we did mention them where possible. One of the things that we recognize is that Muslim family law is practiced very differentially in international jurisdictions, and probably here as well, because of the fact that there's such a great deal of diversity among Muslims and Muslim jurors and imams and other leaders, community leaders that guide Canadian Muslim women. So we couldn't sort of have something that reflected every single thing or every single practice, but we tried to make it a high level comparison between different practices. However, the good thing about this was that we were able to update the documents, the public documents that are meant for consumption by Canadian Muslim women or anyone else who's interested in these topics, such as marriage, divorce, domestic contracts, inheritance, and so on. They're available on our website. And we conducted family law workshops across the country. Again, they were, some of them were in person pre-COVID, and then after COVID, they were virtual. The recordings of some of those webinars is available on our website. One other outcome of the initial work that we did in this area was to develop a sample Muslim marriage contract. And we're going to talk a little bit about the contract in a few minutes, but this became our sort of the most popular document. Everybody wanted to see it. You can download it from our website. It's designed to be a model, and it's actually fashioned after other Muslim marriage contracts in other jurisdictions. So there's a lot of similarities with what you might see in, a nikah form or a marriage contract form from any Muslim majority country. So that's sort of the background. And then for the longest time, we would be getting calls and inquiries from Canadian Muslim women who really were looking for lawyers and also Muslim, imams or leaders who could guide them. And it was very ad hoc, we would sort of randomly find somebody to do it. So we decided to systematize this, and we applied for money to the Law Foundation of Ontario, and were able to secure funds for our Muslim legal services, legal service coordination pilot program. And this seminar is part of that program. It's a commitment under our contract with the Law Foundation. So the first year of the pilot, we basically were setting up systems and doing reviews, learning from others. This past year, we've been actually serving Muslim women, and it's been an interesting experience. And based on that experience, we've assembled you today to talk about, the kinds of things that we've seen occur and the kinds of services and challenges that Canadian Muslim women are seeking when it comes to family law. So we will be talking about that. So without further ado, I'd like to welcome our panel this afternoon. Can we have the next slide, please? Oh, I think before I do that, I do want to acknowledge our partners. They worked really hard with us to promote this. So of course, the Canadian Association of Muslim Women Lawyers, the Law Foundation, for funding the project, and the Barbra Schlifer Clinic, and also Access to Justice Week. They're partners in promoting and also providing us with guidance. Thank you. Next slide, please. So I've already talked to you. Sorry, I've gone over time, but we're going to be talking very, very soon with our panelists. So we'll have our discussion. We'll hear from Dr. Barbara Landau briefly about alternatives to family court, and then Sabrine will moderate a Q&A with all of you, and then we'll close by 3 o'clock. I promise that I will try to get you all done by that time. So if there's sunshine outside, you could go enjoy it. All right. So I'd like to introduce you to each of our panelists. And Aisha is no stranger to CCMW. She has helped us previously, especially when she was working with Dr. Julie McFarlane. Aisha is a barrister and solicitor practicing here in Toronto, and she obtained her honors Bachelor of Arts degree from the University of Toronto and her Bachelor of Laws from the University of Windsor. As a law student, Aisha taught her first year criminal law tutorials for Professor David Tanovich. Aisha also worked as a research assistant to Dr. Julie McFarlane, where together they collected the first empirical research of Islamic divorce processes in Canada. After law school, Aisha completed her articles of clerkship at the prominent law firm La Fontaine and Associates. Aisha was called to the bar in 2011. As a lawyer, Aisha has appeared before the Ontario Provincial Court of Justice, the Superior Court of Justice, and the Ontario Court of Appeal. Aisha practices predominantly in family law. Aisha helps families navigate through the separation process by providing support and legal guidance. And then our next panelist is Rania Bukhari. Rania is an advocate for survivors of gender-based and sexual violence inside and outside the courtroom. She currently works as a staff lawyer at the Barbra Schlifer Commemorative Clinic in Toronto, where she provides legal services in the fields of immigration, refugee law, family law, and sexual assault law to women survivors of gender-based violence. Rania served as one of the Law Foundation of Ontario's Public Interest Articling Fellows and completed her articling fellowship at the clinic. She attended the University of Ottawa Faculty of Law and has extensive experience providing legal services to vulnerable populations across Ontario, including survivors of violence, refugees, self-represented litigants, and individuals experiencing multiple and intersecting marginalizations, such as poverty, homelessness, discrimination, precarious immigration status, etc. Rania's legal practice is grounded in a trauma-informed, intersectional, and anti-oppressive lens. Amazing. Both of you, Aisha and Rania, are lawyers. And last but not least, I'm pleased to introduce you to Dr. Timothy Giannotti, who really loves Toronto, but is temporarily, I'm saying Timothy, working in Chicago in a really exciting position. So he's the new president of the American Islamic College, the AIC, as well as a member of the academic faculty. Dr. Giannotti is an accomplished scholar of classical Islamic theology, philosophy, and spirituality with strong interest in Islamic psychology, moral theology, ethics, political thought, comparative religion, and spirituality and interfaith relations. More specifically, he is a scholar of Abu Hamid al-Ghazali, one of the most important religious thinkers of the classical period. Dr. Giannotti is also recognized as a Muslim theologian, pastoral leader, and committed interfaith advocate with extensive experience promoting interfaith engagement around the globe. So welcome to our panelists, and we're going to get started. I know we're anticipating lots of lively discussions and learning. So maybe we could change the screen format so we can actually see our panelists. Thank you. And there's Barbara. I see you. How are you, Barbara? And I'm going to do introductions to Barbara later on. Okay, welcome everyone. And I'm going to start by asking our opening question. And it's really to ask, Timothy, you can jump in, but I think the lawyers will have a lot to say about this. So what kind of justice limitations have you seen for Canadian Muslim women that are seeking family law counsel? So if you could identify some of the gaps and limitations in the justice system for Canadian Muslim women. Who wants to go first? Aisha, would you like to go first? You're muted. Great.
Hi, thank you. Thank you for that lovely introduction. So I guess limitations, there's quite a few, but some that do come to mind are particularly with clients who are seeking legal aid or who have legal aid. And recently, legal aid made some changes where they didn't provide lawyers with hours for, I guess, just the discussions for a separation agreement. And so they limited that part of it. But I found that with many of my Muslim clients, the Muslim women that were coming to me, that was a really important part of the process, to have the ability to have those types of discussions with the opposing party, whether it be through a mediator or through an imam or anybody that could help them navigate through the issues that they were working with. So that's a difficulty. However, I had many discussions with legal aid, and they basically simply advised to just ask for more hours, try to indicate where some of those gaps are, and they can try and help in that respect. So that's one practical limitation that I find that sort of limits the type of help that they can get, that allows them to go seek a process that's outside of court, because they come with a certificate, and that certificate is tangible for using in court, and it doesn't allow the lawyer to work or have hours to work in other processes. So that's one that comes to mind. Another limitation I find is that just having people who understand some of the challenges that they may face that are unique to them as their Muslim, like as a part of their Muslim identity. I often get clients say to me, well, you know, he just didn't understand, or he or she, referring to a previous lawyer or trying to have a consultation, they just didn't really understand my issues and the way my family, the way some of the dynamics between us are, and it was difficult for me to explain, which is I'm sure is a common limitation that's, you know, reflective of many people, many communities, not just the Muslim community, but I do find that that comment quite a bit. So just have the lawyers and the legal profession having that cultural competence to really understand some of the issues and get into that.
Great. Thank you, Aisha. Rania, you want to join us on this?
Yes. First of all, thank you for the introduction and invitation to speak on this panel. I'm really looking forward to the engaging discussions that we're going to have. Before I answer the question, I just want to preface by saying that, you know, my practice is specific to a particular clientele, which is women that are experiencing gender-based violence, whether that's, you know, domestic abuse, sexual violence, human trafficking. So I am going to try to you know, talk about kind of my experiences working with that specific clientele. But I just want to, before I do that, I just want to give a disclaimer that, you know, gender-based violence is not something that's specific to any particular community, you know, whether it's, you know, racial, cultural, religious community. This is something that is unfortunately an ill that's plagued in every society. So I just wanted to give that little disclaimer. But I think there are a lot of barriers that women experience in terms of accessing legal support and legal services. I think the biggest thing is the lack of knowledge about their rights, both under Islamic law as well as Canadian family law. And I think especially in terms of people that are experiencing domestic violence, there is this pattern that we see of a lot of misinformation about Islamic rights. And even you know, family law rights under the Canadian system, a lot of that misinformation is peddled by abusive partners as a kind of mechanism of that coercive control. And I think something that you know, I do see in the Muslim community is that there is also a reliance on the opinion of community elders. And there was a kind of deference to their, you know, legal opinion on what, you know, the Islamic law says about certain issues relating to family law. But these community elders might not be necessarily actually formally trained in Islamic law, but there is that kind of deference given. And especially for Muslim communities that are, you know, located in rural areas or geographically isolated areas that have smaller communities, they might not have that diversity of religious belief that's reflected in the religious authority. So there might just be one or two imams, for example, if it's a smaller community, that's like the only resource that they might have available to them. In terms of women that are experiencing, you know, abuse, there are a lot of barriers that, you know, that community faces in terms of reaching out for support and, you know, getting help from escaping their abusive situations. And a lot of that is, again, not particular to Muslim community specifically, but it's, you know, it is something that, unfortunately, we do have to navigate as service providers. And that is, you know, a lack of financial resources. So a woman not working, not having savings, being burdened with childcare responsibilities. So really worried about what's going to happen post-separation. And we do know about the concept of the, you know, feminization of poverty and how women post-separation are at a higher risk of facing poverty. And I think there's also, you know, a social stigma aspect of it, which is this fear of being, you know, blamed by the community, you know, by the in-laws, by the family for experiencing or enduring abuse. And I think something that is also a little bit unique to the Muslim community is this fear of reaching out to the state for support. And by state, I mean, police, law enforcement, government. And I think that hesitance can come from like a fear and mistrust of those agencies because of historic and even present kind of neglect, or behavior that those agencies have taken to kind of undermine the trust that the community should have in that community. And then lastly, I just want to talk a little bit about migrant women. So women that, have immigrated to Canada, there can be, language barriers that can be a huge issue in them finding a lawyer, navigating the family law system. There is a fear of deportation, a fear of reaching out to, again, police or state services for concern that might lead to some sort of, informing of immigration authorities and lead to immigration consequences. And then we do also see a lot of cases of spousal sponsorship, where the abusive partner uses a sponsorship as a tool of abuse. So threatening to kind of withdraw that sponsorship if the woman reaches out for support or seeks help. So those are some of the things that I see in my practice a lot.
Thank you. That's all very large, lots and lots of issues. Actually, I wanted to ask Timothy specifically about, so we're talking about barriers to justice. So let's also talk about barriers to justice within Muslim communities. One of the things we've seen, and there's such a reliance, and Rania pointed this out, that people rely on advice from their families and what the families are saying. And then they will also, the family will take the individual to the imam, for instance, for advice. What do you see are some of the challenges that Muslim women face when they're trying to access services from their imams or from their local religious leaders?
Well, thank you, Nushat, and I just want to thank my fellow panelists. I feel absolutely outclassed here. So today will not be an exercise in mansplaining it, because I really feel that I'm coming to this not with legal expertise, but just really with anecdotal pastoral experience of women who, for whatever reason, came to me for refuge or for counsel, and then I kind of experienced or began to experience many of these issues within the community through the lens of the privileged lens of the trust and the needs of the community. And so, I think that I've never been approached by someone who was well connected in Canadian society or had resources to pay. So money is never an issue, but money is in a way it cannot be an issue. And so I think there are many women who never ever make it to a lawyer's office, or who never ever fill out the paperwork that is required for legal aid or any other kind of state-sponsored assistance, because they're not in a financially strong position, nor are they in a well-connected position with Canadian authorities. And I think also within the community where we live still very much within a patriarchal system that doesn't really see domestic violence clearly. And so a lot of those imams that people would bring a woman in crisis to themselves are not sensitized adequately. And so they do not understand the relationship between sexual violence and power, for example. Very often imams trained in a Deobandi system or other traditional systems can only understand sexual violence in terms of desire, and in terms of maybe there was too much showing, maybe it was her fault somehow, or maybe, and so I think that there's while there is, I think, a lack of cultural competence within the governmental and legal world in working with women coming from these marginalized communities, I think there's also a tremendous amount of ineptitude and lack of learning with regard to cultural competence vis-a-vis, interacting with Canadian culture and government and other departments that can be of assistance to women in these situations. And also I've also had young girls and boys come to me for assistance, and again, they're coming from environments that just don't really know what kind of assistance is available to them. And then also I think that and I know that we have some imams even in the community that's gathered today, and I see many dear friends who are here, including Barbara, who's right in the middle of my screen. So it's a humbling privilege for me to just be part of this conversation. But I think that that also working within an Islamophobic context, I think many imams also are afraid to share the community's dirty laundry with Canadian government and with the media. And so very often people would be counseled not to go for help, not to go for government help, not to go for legal help, because the fear is that we're just going to, fuel the fires of these people who think of us as being depraved or being, that there's no way that we can successfully integrate ourselves as a community with the larger Canadian context. And so very often then the shame culture, as well as the cultural incompetence rather, of many of our religious leaders, and the fears of this, the fears generated by an Islamophobic context. I think there are many reasons why even the people that they go to for assistance and for guidance themselves don't really, they become more impediments than catalysts for women who are seeking help and seeking resources. And so, I think we're dealing with such a multifaceted problem. But of course, the fears that were previously laid out, I think are very real. Fears of poverty. I have sisters that have come to me because they're desperately afraid of losing their mahar. I know we're going to talk about this, but they're desperately afraid of poverty. And so in that, there's a real kinship or affinity between their fears and the fears of other women who are in vulnerable places and in captive within domestic abuse houses and scenarios. I know also that within our community as well, and I speak of, when I say our community, I mean the Muslim community more generally. I'm speaking more ecumenically now and more inclusively of all of the different communities that are represented within the Muslim mosaic. But I think that generally we do have a debilitating phobia for what other people might say or think within the community. And so I think that fear of social stigma is also a massive impediment to justice and to seeking help, to people in vulnerable situations seeking help. And so all of the points that have been raised resonate very powerfully with my own experience. And so I think that, but we do need to address, I think, the cultural incompetence of our religious leaders. And I'm not painting all the religious leaders with one brush here. I know that there are many religious leaders who are very integrated and very savvy and very can be wonderful allies to people in these situations. But I also know that there are others who would actually, and I see this here in Chicago as well, who actually will take a victim of domestic violence and seek to reconcile her with an unrepentant abuser. And so, because the idea is that reconciling the family and getting her back in the house is the chief priority, whereas we could just as easily invoke the prophetic model of the hijra, or the migration from an oppressive environment like Mecca was for the Prophet to a safe environment as Medina was. We could easily invoke that scenario as being as Islamically correct as reconciling the family. But very often the victim of domestic violence is then encouraged by a religious leader to go back to the abuser, to go back to that abusive situation, And almost always the abuser is not required to go through any kind of process of transformative process of rehabilitating himself. So
thank you. So we've heard a lot about the limitations or barriers that exist both in our own faith communities as well as in the legal system. There's one common kind of call we get because people recognize that there are these limitations and there are these barriers. So some Muslim women who've contacted us, especially the younger ones, who are getting married for the first time, and they've said, I want to get married. I want to have a Muslim marriage or Islamic marriage, but I don't want it registered. So what advice would you have for that young woman who's contacted us or that you would counsel? Aisha, do you want to take it first? You're still muted. Sorry.
Okay, thank you. So unfortunately, I usually get the women who comes to me after the decision's already made. And she says, my marriage, we only had a religious marriage. It was never registered. And the thing is that it really limits their rights under like in terms of property, right? So for example, in Canada, there's no common law rights to property. So if she's in a marriage that's not registered, it pretty much it poses a problem that she could be considered common law at that point, unless she's going to argue the validity of her marriage, which she could also try as well. But the classic scenario is that at that point, then I look into spousal support rights, because they would be considered a common law couple, and based on whatever the circumstances are, we would go down that route. Now, this is a really interesting, I think, in my practice, especially because what I tend to do then is in my intake process, I will ask them about their religious contract. I will go through the elements of that religious contract. I will look to see if there's any meher at that point, if it was written down, if both parties agreed to it, if it was ever paid out. And then I would use that as a negotiating tool for my client to try to get some property per se of the marriage, right? So I do that, or even when I would do this, I would start a spousal support claim, but at the same time I would say that I'm going to be arguing the validity of the marriage, therefore I'm going to be going after the meher, and then use that as sort of as a negotiating tool. So it is problematic because you do limit your rights under Canadian law, especially when it comes to property.
So that's basically what we tell them, that it will limit you in the legal system in case there's a breakdown. So I think those are really valid points. Rania, did you want to add anything else to that?
I mean, the only thing I wanted to add is that Aisha, like you, usually it's too late. I mean, the marriage, it's usually like the abuse has happened, and it's either the client is gearing up for a separation or a separation has occurred. And if for the type of clients that I practice, like with the issues that then become like, what safety concerns are there? So, is there a risk of harm to the spouse or the children? What legal measures can we explore? Whether it's, getting a restraining order through the family court or getting, a peace bond through the criminal court. I mean, the other thing that's I think important is to let a client know that in terms of how children and child-related issues are dealt with, there's no difference compared to if you're a common law versus a married spouse, and that the primary consideration that the court is going to be looking at is the best interest of the child.
Great, thank you very much. Yes, Timothy.
Well, I guess this is one area where gender makes a difference in perspectives, and that's just because I am a male within still a very patriarchal community. that means that people do approach me, right? So I witness marriages, I do burials and all those things. And so I have had many couples come to me, and some, you know, I think one of the few requests for a purely Islamic wedding that I actually went along with was a situation where both of them were Canadian lawyers, and so they just wanted to, they did not want the Canadian legal system. This was something that they both knowingly chose, but apart from a very special scenario like that, I almost always refuse. I refuse to marry a couple or to witness their marriage rather, if there is some kind of desire to avoid the provincial legal system or the Canadian legal system, because I do think that, you know, in the spirit of the mahar, I think that one thing that the provincial legal system does is it protects the rights of both parties, but in particular the woman. I think that, you know, she's much more protected under Canadian provincial law than she is under let's say a document which you know, certainly you know, cases can be made for the binding legal nature of a you know, a document of nikah, but even from an Islamic legal standpoint, a written document isn't even required. And so we're kind of in we get into a, you know, a kind of a murky, dangerous place. And I've known of other people who have officiated or witnessed marriages where the mahar wasn't written down, and so it was never fulfilled, where you know, the woman, especially if the woman is seeking divorce, even from an abusive situation, it's, you know, understood that because she is the one who is the active you know, proponent of the divorce or seeking the divorce, that she then would waive her rights to the mahar, and so then she would have to leave whatever protection she had. And so I do think that within the Canadian context, my counsel is always to make sure that this wedding is simultaneously registered with the province of Ontario, and that the you know, that the religious event or the religious service, you know, is certainly what the families want, and it's what often the couple wants, but it fails to fully protect the young woman. And I think that a lot of that has to do not with the failure of Islam, but really with the failure of a community that I think doesn't fully appreciate the maqasid, or the intentions underlying much of Islamic law.
Thank you. Yes, so it is very interesting. So they actually come to us shopping for someone who would perform a marriage that would not be registered. But so I've had those calls, you know, not infrequently anyway. One other thing I wanted to talk to you about that's related to marriage. So I mentioned our sample Muslim marriage contract. And I don't know if you've had a chance to look at it, but can you talk about legal enforceability of that contract? Are there aspects of it that may or may not be enforceable? And then what would be required, you know, in terms of statutory safeguards? As I said, what we did was we developed a sample looking at marriage contracts in many Muslim majority jurisdictions. So maybe, Rania, do you want to take that one first? Are there any?
Yes.
Yeah,
I mean, I can just speak generally, but I think it is important in the contract to actually define mahar and actually define it clearly, so that you can kind of distinguish that issue from spousal support and the you know, family property. And I think it's really important to outline, like, even the religious purposes or the intent behind it, because I think, you know, you cannot operate from the assumption that the judiciary will understand what this concept is for. And I think it's, especially if the mahar involves getting an interest or ownership, a share in the matrimonial home, it needs to be really clearly delineated that that matrimonial home will be excluded from the net family property, because the law is that matrimonial home has a special status, and it cannot be excluded or deducted from the net family property unless specifically stated in a domestic contract. So depending on the type of meher that the client is seeking, I think you can provide advice accordingly. And I think it's also important to get financial disclosure. I think it's important for the in order for the contract to be held valid, like one of the grounds that a domestic contract can be set aside, or certain provisions can be set aside, is if there was a failure to disclose significant assets. And so I think in order to meet that requirement of the Family Law Act, I think it's important, for parties to share financial disclosure.
Great. Thank you. So I think, if you don't mind, I'm going to move right into the mahar discussion, and maybe Aisha and Timothy, you can jump in here, but maybe we could start with you, Timothy, about what the concept of mahar actually is in Muslim family law or in Islam.
Well, again, I mean, we're now in a a realm of interpretation, right? And we know that within the Muslim community, the mahar can be interpreted in a variety of ways. But just very simply put, for people who may not know Islamic traditions or may not know anything about this, in my understanding, the mahar really acknowledges the idea that going into a marriage, that there is a particular kind of vulnerability that the woman takes on, primarily because of her her economic situation, perhaps, or because of the fact that she could be the one who she could be the one whose career is sacrificed because of children or other concerns going. And of course, the mahar reaches back to ancient patriarchal context, tribal context in Arabia, where women were just being lifted out of a context in which they were almost deemed as property. And so the mahar is not a bride price, but it was something rather that the family would often be involved in negotiating as a safety net for the woman going into a marriage situation. And if anything were to happen, God forbid, to the marriage or to the husband, that this would be a safety net for her in that moment of vulnerability. And I think that that our understanding, I think that our understanding of the mahar and marriage, and our understanding of inheritance and the wife's portion of inheritance, a lot of this comes from an ancient situation in which women were really not understood to be equal partners in the economics of the situation of that world. They were not understood to be legal partners in marriage, and so the mahar really then, I think, exists as a token of assurance, as a almost for many people an insurance policy if something were to go wrong. And for many women, that is their that going into a marriage, that becomes one of their primary sources of wealth and security. And so these days there are lots of situations where that element is not nearly as necessary or needed, because women are coming into the marriage as professionals with earning potential and power that is often more than their husbands. And so the original sense of the mahar, then in those situations, the mahar becomes much more symbolic and less meaningful from a monetary perspective or as an insurance policy perspective. But still, the my understanding always when I'm explaining this to couples preparing for marriage is that the mahar really is meant to be something that deepens the sense of assurance, that deepens the sense of security, that would serve as a kind of insurance policy for a woman entering into a Muslim marriage.
Certainly. So I know that with the mahar, there's sort of like you can have payment up front, or you could have, payment at dissolution of the marriage, and that's negotiated in the contract, as far as I understand it. Ghania and Aisha, do you have more to add to how this plays out? I know that there has been some case law associated with it. Aisha, do you want to take that?
Yeah, sure. Actually, I was going to echo Ghania's comments about having that the marriage contract be very clear as to the mahar and showing the intention of the parties. And Timothy, I wanted to ask you a question because I get this question a lot too, and I'm not sure of the answer. But is mahar different than the mu'akhir? Have you heard of the term mu'akhir?
Just means delayed. So
Okay.
it just means that would be a deferred mahar, meaning that like a mahar that, there may be part of a mahar that would be upfront and prompt, and part of it would be mu'akhar, it would be delayed, meaning it would be deferred to a later time. And almost always in situations where, at least that I've been privy to, that mu'akhar, that portion of the mahar, gets lost when a woman is fleeing an abusive situation, and her safety and the safety of her children are often more important priorities than going back to collect whatever was intended. But
so is the meher something that's must be paid during the course of a marriage, irrespective of separation? Is that
right?
Is it the consideration part of the contract?
So a prompt, again, I mean, the mahar can be whatever the couple and whatever the families agree for it to be, but if a portion of the mahar is delayed and not promptly given to the bride, then that technically belongs to her still. And so my understanding of that concept within Islamic law of a deferred mahar is that that is still a solemn and binding promise, regardless of what happens with regard to the marriage. Now, but in a bride, in a wife initiated divorce in Islamic law, if it's deemed to be an initiated divorce without sufficient cause, then her penalty for leaving the husband for no good reason is to give up her mahar. That's part of it. And so very often women who are fleeing an abusive situation are terribly afraid of losing what little insurance that they had in the mahar.
Okay, thank you for clarifying that. So back to what you were saying about the case law. There was a case, the Ontario Court of Appeal, Khanis versus Noor Mohammed. In that, the court examined whether or not the mahar would be deemed enforceable. They looked for whether or not the contract was in writing, whether it was signed by both parties, whether there was free will. And this case was interesting because the judge ordered it excluded from net family property, because that would mean that it would undermine the intentions of the parties when they were making the contract. So what happened was the husband tried to say, okay, well, even if it is enforceable, I want you to count it as against our debt that we both owe. And the judge said, no, we're not going to do that, because that would undermine the intention of why you guys had it in the first place, the mahar in the first place. So that was an interesting case for that purpose. I want to also mention a really recent case, 2021 case, Iqbal versus Shah.
Aisha, you're fading away. Can you speak closer to your mic, please? Thank you.
I wanted to mention a very recent case, Iqbal versus Shah. It's a 2021 case. This goes back to the first part of what we were talking about what predicaments people would find themselves in if their marriage was not registered. And in that case, particularly when they were trying to examine the validity of the marriage contract, it was the wife, I believe, who did not have a legal divorce from her prior husband. And so that was a factor that the courts considered when they said, well, she was not eligible to enter into the marriage, the nikah, to begin with, because she didn't finalize it. And she only had an Islamic divorce before, but not a legal divorce. And in Canada, you need a legal divorce in order to enter into civil marriage. So that was interesting, that part. So yeah, those are the two cases that I would probably highlight.
Okay, so there's a request from some of our audience to put the cases in the chat box if you're able to, please, Aisha. And also there's a very detailed case from one of our participants, and I would encourage you to contact Sabrine. Sabrine, if you could just provide your contact information in the chat box as well. There are some people who want to actually, they have ongoing cases they want some assistance with. So that would be great. Rania, did you have anything else to add on the mahar?
No, I think we addressed it sufficiently. Yes.
Thank you very much. I know it's always yeah, go ahead.
No, I just wanted to note that in the chat, it was also shared that even if the husband were to die,
Yes.
that his deferred mahar, which has not yet been paid, could be taken from the estate, meaning that the widow in that context would have a claim against the estate, because the idea is that the deferred mahar is still a binding obligation, and and when and how it is fulfilled, I guess, is up to the ongoing negotiation of the couple, but and the circumstances of the husband in some cases, but this is this is important.
Mm-hmm. Sorry, go ahead.
Sorry that we only have 10 minutes left for the remaining
Yeah.
portion of this panel.
And thank you, Sabrine, but I am going to, if we have to go a little bit over, I'm sorry, we're going to bump into the Q&A part, but this, some interesting topics still for us to cover, if you don't mind. So I'll just take, I'll be indulgent and take a little bit more time. So thank you. That was a really interesting discussion about mahar. Next, we're going to come to divorce. So there are two aspects to the divorce questions that I want us to address. One is the way some people practice divorce in our communities, and I'll give you some examples of those. And then I want to talk to the lawyers on our panel about the changes that have occurred in the Divorce Act and whether or not they've had impacts on Canadian Muslim women. So over to you, Timothy, about the kinds of calls we get. We had one woman say that she was divorced over the telephone when the husband told her that I divorced you 3 times. That was on the phone. Nothing, like no paper, nothing. So he considered himself divorcing the woman, and she called in a panic saying he divorced me on the phone. Other situations that have actually occurred, and we're familiar with them, is when the man has sort of face to face to the woman and pronounces talaq, 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 right? I give you talaq, or give you divorce, I guess, if you want to call it that, 3 times, and then sort of steps away and lives in another room until, they separate physically in different locations. So those are some, from my understanding, those are the worst form of divorce in Islam. So maybe you could sort of enlighten us on what it really is supposed to look like if there is a divorce.
Yeah, well, it's there's a vast array of interpretations about the 3 pronouncements of divorce, the exclusivity of the male right to divorce, and so there are scholarly opinions that would suggest those 3 statements should actually be counted as one statement because they're happening within one moment, one time. Then there should be time for separation and for reconciliation and discussion, and but very often when we're talking about women in vulnerable situations, it is the woman's right to divorce, the woman's ability to divorce, which is what is the main topic of conversation. And so I think that again, I mean, we're dealing with within a realm of a spectrum of interpretations with regard to what the rights of women and men are with regard to divorce. And many women are culturally brought up to think that only the man has the right to pronounce a divorce, and that women in these vulnerable situations often then don't know what their rights are. They don't know if there is a way for them to seek, Muslim authorities and to win a divorce from an abusive husband, or from a situation which was, just very unhealthy for them. And so I don't think that it's within my ability or the ability of any Muslim scholar to say that only this counts as a divorce, because we're really dealing with community perceptions. And so regardless of what a scholar might say here or there, what's really important is what the family thinks a divorce is, and what the couple thinks, or within that particular madhab or legal environment or religious environment, that what they understand divorce to be. And so I think that again, like the mahar, I mean, divorce is a big topic with lots of understandings, but most of the cases that I have that have come to me have been cases where the husband isn't interested in a divorce, and it's the wife who is I guess desperately seeking a way out of her predicament, out of her situation. And so I think there needs to be a lot more discussion about female initiated divorces within a Muslim context.
So a common, call that we get is I would like to, I want a khula. That means I want to, seek a divorce from my husband. Very common. And then what we do is we do direct them to, let's say, Aisha or one of the other lawyers, so that they can be properly counseled about what that means, and the necessity for a legal divorce if they really, want to ensure that it is binding. And because we've seen things happen, like they do the pronouncement 3 times, but then they say, no, we're not really divorced. So it sort of keeps the woman dangling.
Of course.
So I wanted to see if Aisha and Rani, if you had any further comments about this, and what happens when you have a client that has, that comes out and reaches us and says, this is how I was divorced. What should I do?
Tanya, would you want me to take this, or? Yeah.
I have some thoughts I can start with. I mean, in my practice, I see a lot where the abusive partner uses this, what he perceives as a religious right to instant divorce or triple talaq as a kind of tool of abuse, and essentially weaponizing a religious right, as a form of psychological or emotional abuse, domestic violence against the woman. And I think it's really distressing for clients, because they actually do believe that this is, a right that the husband has, and that they're, it's at that point, I think there is a responsibility to refer the client to an appropriate religious scholar to get, some religious legal advice around that piece. But in terms of, how it affects, like whether or not that's a valid divorce under Canadian law, it's not, right? Like there's very specific grounds under which you can bring a divorce. And my advice to a client would be like, one of the grounds is 12-month separation. So if this is something that if you want to get divorced, then establish that separation. Or we can also explore bringing a divorce application under the cruelty ground. But I think it's because this is a tool, a form of psychological or emotional abuse. I think a lawyer that encounters a client who's coming to them with this type of issue I think it requires a lawyer to do a more fulsome risk assessment to see what other types of abusive or controlling behavior is happening in that relationship. And I think it could really flag there might be other things that are happening in the relationship, other forms of abuse that the client is not, either doesn't recognize it as abuse or is doesn't think is legally relevant. So I think it's important to do that risk assessment, and after you do that risk assessment, doing safety planning, providing appropriate referrals to the client, not just in terms of religious leaders, but also in terms of getting access to counselor, therapist, other support persons.
Thank you. I think we're going to move on to the next really interesting and juicy topic, which is polygamy. So we've gotten calls from women who find themselves, quite unbeknownst to themselves, that they're in a second or third marriage, that the spouse already has maybe a spouse somewhere else in the world, or already here, a separate apartment and kids. And it's only when their marriage, whether it's the first one, second one, or third one, or even fourth one, that is breaking down, that they discover that they, in fact, are not legally married, because polygamy is illegal in Canada. And secondly, the fact that it's prohibited under the criminal code, there is a stigma in our communities to do anything about it, like to take anyone to court, to be public about it, because of the Islamophobia that exists and the bad name that people are going to get because of the publicity around cases like this. And even when it comes to prosecution under the criminal code, really the one case we know of is the Bountiful case. Other than that, there hasn't really been anything tried around holding the perpetrator or the individual committing multiple marriages to account in any way. And when we've talked to religious leaders, they say, no, we don't perform, a second marriage. No, it's right on our website, the Council of Imams website, that they will not do it. However, we know it's happening because the women contact us, and we know of women who have lived in polygamous families and are living in polygamous families. So can we sort of shed some light on the issue of polygamy? And maybe, Timothy, we can start with you about the premise in Islam, because it's so misinterpreted and so misguided and abused from my personal perspective.
Right. Well, yeah, and there's also the issue, just for our notes, there's also the issue of temporary marriages, right, which are often polygamous and feel like infidelities to the wife, to the I guess the full-time wife, and often end badly for everyone involved. But according to my reading of the Quran, and we've had I remember back some years ago, and I know that we have some members of the Canadian Council of Imams on the in the community gathered today, and it's absolutely right that the Canadian Council of Imams has stated very clearly and very publicly that these polygamous marriages are not performed or not witnessed by the imams by agreement. But that said, there are imams who themselves engage in polygamous marriages, and so I'm not saying that members of the Canadian Council of Imams do, but because there is no ordination, there is no priesthood within an Islamic context. Marriage is not within my power or the power of any imam to perform. That's why I always use the word witnessing a marriage, because marriages can be witnessed quite informally. They can be done in one's basement or one's home, and so a Muslim marriage can be done quite informally. And so it's impossible for us to regulate that practice in a meaningful way. Because there are many Muslims who may or may not attend mosque, or who may or may not have a relationship with an imam or a learned religious scholar. But my understanding is that the permission in Surat An-Nisa, the permission for multiple marriages comes only once in the Quran, and it comes within a very specific context of concern for the welfare of orphans. And so my understanding with regard to the asbab an-nuzul, or the context in which that permission is given, is that this is given at a time when there is an active state of war, where husbands and fathers are being killed, where concern for their children and their families was growing within the community. And there was no mechanism, no safety net, no mechanism by which those bereaved wives and children could be taken care of. And so when the Quran says that if you are afraid for the welfare of these orphans, then permission is given to marry, right? And so that permission then up to 4 is given within a clear Quranic concern for the social welfare of that early community. Very often a bereaved wife or a young mother would go back to her family. But in this case, many of those families, now the community is based in Medina, many of those families are back in Mecca, when those families were adamantly opposed to this monotheistic movement, this prophetic movement of Islam. And so that would have meant reverting from monotheism back to polytheism. There were all kinds of issues at play. And so we can only assume that many of those issues are informing the Quranic intention there behind the permission, which is given only in one place for multiple marriage. And so that said, that even understanding that within a Canadian context, where there is a social net and where there are other safety measures in place, and where the clear law of the land is for legal monogamy, then there is no license given to Muslim scholars then to issue legal permissions or Islamically informed legal opinions in defense of polygamous marriages performed in a country where they are explicitly forbidden in the legal code. And but that said, it's remarkable how prevalent they can still be, both in the form of temporary marriages and in the form of marriages that are just informally contracted, so that when the scholar is in town, he has a local marriage, let's say, to take care of his needs, the way it's often portrayed. Now, there are a few situations in which I've spoken to extremely learned and liberated feminist women who have their own reasons for supporting the idea of polygamous marriages. And so I have to say that it is not always the convenience of the man that is at play with regard to polygamous marriages. And so there are women out there who really enjoy the freedom that being a second wife or a third wife can afford them in the light of their own professional career and their own situation. But those conversations, in my experience, have been much fewer than the conversations I've had with with the victims and the survivors of multiple marriages that were not understood to be such when the woman entered into them.
So one other provision in the same verse is that because is around treating all of the wives equitably or justly, and because the premise is that justice should prevail, because you cannot be just to all 4 equally or more than one equally, you should only marry one. I think that's the rest of the verse, from what I can know.
That permission also comes later in the chapter. So I didn't want to,
I know,
a Quranic study session, but
yeah.
But so there is a preference stated, but the legal permission is given. And so, as is the case in many legal precedents, and again, I'm totally outclassed in this discussion by my sisters who are lawyers and other people who are legally trained here, but But once the precedent is given, then people can do all kinds of things with that precedent. And so that's what we've seen in many Muslim cultures, where it's considered to be, in many, I wouldn't say many, but in some Muslim cultures, it's considered to be the man's right. Again, just like divorce earlier, it's the man's right and privilege. And God understood male, I guess the insatiability of the male sex drive. And so God created this precedent for the convenience of men, so that, other societies, I've been told, have fornication, but we have multiple marriage. So we do it responsibly. And so I've heard that so many times, I can't even remember all of the contexts in which I've heard that. But that clearly is not what the Quran is talking about when this permission is given in one context only for multiple marriage.
Okay, thank you so much. I know that's a very complex topic, and I had wanted our lawyers to talk about what happens to a spouse in polygamous marriage if there is a breakdown. I don't know if we have time to cover that, that topic, because the women who contact us, they contact us because either they know that the man has another wife, and what is their legal recourse, and then secondly, if the marriage breaks down, the second or third marriage breaks down. Briefly, if you could answer either, Rania or Aisha.
So again, this usually, a client comes to me, it's already done. They're in this polygamous marriage. From my perspective, from my purpose, I don't necessarily, go into the validity of that, or whether it's right or wrong or what happened. I'm like, okay, what now? What can we do now? So I ask the regular questions that I would ask any client. Do you have children? How long have you guys been living together? Because I want to be able to figure out the grounds for the orders that I would be seeking. So if they share children, how many children? Because then I could seek some child support for my client, or spousal support, given how long you've lived together, and any other orders that I would find would be helpful to my client at this point, because they would be coming to me for legal help. So with respect to that, that's where would be my focus of assistance. And Ganya, if you wanted to add to that.
I just wanted to add something which I feel like is important for us to talk about. I think one thing that I see in my practice is that while the husband might not be able to get a religious, authority within Canada to do the second marriage, they do go overseas and get that second marriage arranged overseas. And I think this is a really interesting area of intersecting legal systems within Canada, because the idea of polygamy is actually governed by 3 different legal systems. It's criminalized by the criminal court. There is obviously family law implications. And then there is the immigration law aspect of it, in terms of being able to sponsor that second wife, if that second wife is overseas, and what happens to the children of that second wife. Can they be sponsored? So I think it's a super interesting and complicated thing. And I think one thing that Aisha and Timothy both raised that I think is really important, which for me is really encapsulates that anti-oppressive practice, is the idea that there are Muslim women that do believe, that agree for their husbands to marry, to have a second or third wife, and that's something that they believe and they accept and they agree to it. And I think given by the fact that this idea, or this polygamy is governed by 3 different legal regimes, and it's very controversial. Obviously, everybody has their own biases and personal opinions about it. But I think, when it comes to actually providing legal service, we have to provide service in terms of what the client wants in their outcome, and what they believe is in their best interest, and avoid some of these paternalistic or maternalistic attitudes of I know best for my client, or peddling in these kind of Islamophobic or cultural myths about certain communities accepting this type of practice. I think we really have to avoid that and provide support to our client.
Thank you. That's very helpful, because often there's pressure for us. Why aren't you doing something? Why aren't you challenging this in the courts, because it's against the law and so on. So yes, it's very client centric, our thinking and what would be best for the client, what the client wants. Last but not least, I know we're running out of time and we do want to hear from Barbra shortly. This is a really big topic, but inheritance is a very popular topic. Any workshops we've had on Muslim family law, everybody wants to talk about inheritance. So we know that there's a very prescribed, sort of set of rules around inheritance. They're all spelled out very, very clearly about who gets what, how much, that is when the individual passes away, and then there's a distribution of the estate and so on. But then there's also the provision that a will can be made before a person passes away, and that is binding regardless of what the rules are that are spelled out by who gets what in a family. So Timothy, I don't know if you want to add anything to that very generic comment.
Well, just again, I mean, I think we have to be mindful when we're talking about, Quranic exegesis or interpretation, we have to be mindful of that original context in which, women were often, in pre-Islamic Arabia inherited rather than inheriting, any of their husband's wealth. And also that early society where a woman's wealth was understood not to be accessible to her husband or to anyone else, and that his responsibility was to pay for the needs of the family and for everything that would be considered necessary in food and shelter and the education of the children or whatever. And so we're obviously living in a radically different context today than they were living in that situation. And so one of the interpretive questions that we have to ask, and people come down on different sides with regard to this, is whether this is descriptive or responsive to a situation that was existing then, right? Mm-hmm. Which was making reforms that were radically in favor of the woman's right and the woman's personhood and her humanity in that situation, or whether this is proscriptive for all time, meaning that this is the way it must be for all societies in all times, regardless of how society evolves or changes. And so this is again a very interesting and very important interpretive question for us to ask, and it's also informative for us to just, or instructive for us to be mindful of the fact that even as society evolved throughout Islamic history, there were all kinds of other mechanisms by which fathers could give their daughters more inheritance, or they could give their wives more inheritance, that when they died, everything was divvied up according to the Quranic, dicta. But prior to that, they could establish, endowments for their daughters or positions. And so there were all kinds of legal mechanisms by which people could circumvent these very clear and very unambiguous, Quranic dicta with regard to inheritance. And so in my view, I think we have to readdress the intentionality of that in its original context, and then ask ourselves, what does it mean to be faithful to that intentionality in the world today? But again, that's my own personal interpretive approach to this. But there are, of course, again, a whole range of interpretations.
Sure. I'm sorry, maybe we'll have to do another session to talk about, family property and that whole sort of how do these inheritance laws, play into that. We unfortunately are running out of time. So, stay tuned. Maybe we'll schedule another similar discussion with all of you. And I know I've taken up a lot of our audience's time. And also, Barbra, I know you're here and you want to talk briefly about the hub. So we do want to give you that opportunity. And I want to thank Aisha, Ganya, and Timothy. Hang on, you're not off the hook yet, because we'll have audience questions in a few minutes. So Barbara, can we hear from you about the hubs? I know it's a very exciting project. And just briefly, Dr. Barbara Landau is a lawyer. She's a psychologist, mediator, and president of the Community Hubs for Separating Families. Also, she's a very long friend of CCMW and my personal friend from the Canadian Association of Jews and Muslims. So over to you, Barbara.
Don't do it yet.
Go now. She's ready.
Yeah.
Listening. Say hi.
1 second. Oh, there I am. Okay, I am going to say hi. I'm going to say Salam Aleikum Aleikum Salam. And I am going to, I am here as the co-chair of the Canadian Association of Jews and Muslims, as well as the president of these community hubs. I'm going to go over this very quickly, but I want to just start by thanking the speakers for presenting so well on this issue, and that so many of the issues that you raised are just as true for the Jewish community and for other vulnerable, particularly women of color and low-income communities. So I'm going to run through this because I know I've only got a few minutes, but let's do another session. Okay, so if I start from the beginning here, let's see if I do from the current slide. I'm a technological not whiz kid. So if I tell me if this is, you're seeing the slide?
Yes, we are.
Oh, okay, good. Okay. So I have created an initiative to resolve, at least in part, some of the issues that have been discussed today. I've created this initiative because of the issues we've talked about the lack of access to justice, particularly for vulnerable women. I'm going to run through this. Okay, so who are we? What basically I've created, and I've sent a brief article to everybody, is community hubs. The intention is, in this national not-for-profit, is to have community hubs for people who do not need or want to go to court in as many communities as possible, not only across Ontario, but actually across Canada. And so we've got highly experienced, multidisciplinary professionals. You've got Kavita Bagat as one of my hub leaders in the participant list. Multidisciplinary, committed to changing the way that the family law system works. It does not provide adequate access to justice. It's not affordable. It's not timely. And so now we're going to go to the, let me just see if I did. Okay, I'll just keep going here. Okay, so how does this community hub work? Starting off, most legal processes seem to start off with the idea that people divorce because of the law. They don't. They divorce because their relationship is in trouble for a variety of reasons. So when people come to our community hub, we are thinking about, why did they separate? What are they most concerned about? And usually there's a whole range of issues they're concerned about. What are they hoping for an outcome? Our goal is to be client-centered. Find out where the client is at and what do they need? What kind of dispute resolution options have they thought about, either within their faith or within the legal system? What process would most likely achieve their goals? Okay. So now we're down to, okay, how can we be found? We're just updating our website. So some of this is still a work in progress, but we are working very hard. Separationpathways.ca is our website, and we are also accessible through the Legal Innovation Zone's free portal that we created in order to educate men and women about their legal rights and responsibilities. FamilyLawPortal.com, which is a 25-click free educational tool. Okay, so how does this work? I'm going to give you the quick overview and then give you a little bit more information. Whoops, here we go. Stay with this one. Okay, we've got 3 particular steps in our process. And the reason I'm speaking to you today is I'm hoping we can get all of you to be wanting to participate and offer services in our community hubs. Okay, so the first thing is intake. And I'm going to tell you what intake is about in a minute. Intake is we get a call, or we get an online questionnaire, and I'm going to tell you about that in a minute. The next step is, whoops, this is jumping around here. The next step is a separation planning meeting. This is probably the most important part of our service and the most unique. Rather than starting off with instant legal advice and an assumption that people are on their way to court or on their way to a particular legal outcome, we start with a planning meeting. And that meeting is a one-on-one, low cost. You get up to 2 hours of assistance for a flat fee at $150 in order to find out, well, I'm going to go through what is the separation planning meeting all about. So intake, separation planning. At that point, if we find out that you are really interested in more legal issues, we'll send you off to the portal, the free portal, to get you organized about what information you need. And then out of that planning meeting, everybody gets their own personal separation pathway, their own plan, which helps them, guides them as to what kind of individuals or service providers would be helpful to them, and they get a referral to that, and that leads to a resolution. And the resolution may be that they want emotional help. They want, we're going to go through it quickly. I'll jump to this quickly. Okay, so let's look at the intake. What's required at the first step, the intake? There's an online questionnaire that's very brief. It starts off, because of my long association with the Barbra Schlifer Clinic, it starts off by asking about safety. Are you safe? If you're not safe, go directly. You get immediately referred to a women's advocacy resource in your community. And the other question we have to ask is, are you already in the middle of a court action? If you're in the middle of a court action, our separation planning meeting may be irrelevant. We need to connect you to low-cost legal assistance, and we are connected to JusticeNet as one of the resources for low-cost legal services. Okay, if you're safe and you're not in court, we set you up with a separation planning meeting based on what you've indicated in your brief questionnaire are the kind of priority issues you've got at this point in your path. We set you up with, it may be immigration issues, it may be emotional, it may be special needs child, and it may be legal, or it may be financial. I just don't know how I'm going to manage to provide. Okay, maybe affordable housing, whatever it is, we're going to set you up for a planning meeting about that. Okay, and now you're in the separation planning meeting. This is a professional that's agreed to do this up to 2 hours planning, helping you to identify what the key issues are that you're concerned about, and looking at coercive control. Like, even if you are safe, you may still be under somebody's control. So we have to look for coercive control. We have to look for priority issues. We have to look for what their understanding is of the different processes they might choose, and what they think their partner will accept as a possible process. And we then create a plan for them and then help them with referrals to local assistance. Actually, right now, because everything's happening online, we've started with online intake, online separation planning, and even services online, because people can get counseling or legal assistance online. Okay, and so this is our call to action. We need qualified lawyers, mediators, therapists to join our roster. We are asking that people accept clients at a somewhat reduced rate, well above legal aid, well below Toronto high-end, my old Bay Street office. And we need you to get the word out that there is this kind of a service available, a community-based, supportive, concerned about safety, concerned about where that client is at, and concerned about getting you to qualified resources. And so we need people for our separation planning roster and our multidisciplinary professional services roster. And it's time to get going. So I'm going to end my stop share. Whoops, there. Okay, so that's what, did I do it under time?
You did really well. So you did really well, Barbara. Thank you. And thanks for joining us today. It's great to see you.
You're most welcome. And I see so many people that I know. So this is wonderful. This is Old Home Week.
Wonderful.
Okay.
You too.
Hey.
Okay, so we're going to now move into our Q&A. I know we have many questions. We're going to try and answer all of them. And Sabrina is going to help us. I know there are comments in the chat box too, but let's get to the questions first that are in the Q&A box. Sabrina, do you want to start with the first question and we'll just keep going? Thank you.
Most definitely. Okay, let's do this. So I do want to thank Dr. Barbara for the introduction to the community hubs for separating families. Dr. Barbara, if you want to add your email to the chat box for those who want to get in touch with you.
Okay.
And before we get into this exciting Q&A session, I do want to acknowledge that the land on which I reside in Adras, Ontario is the traditional territory of the Anishinaabe Mississauga, adjacent to the Mississaugas of Scugog Island First Nation and in the territory covered by the Williams Treaty. Thank you for that. Now let's begin with the Q&A session. I'm going to start with Deborah, who said, another challenge I often identify is related to immigration mixed financial constraints. Oftentimes, a spouse has outstanding immigration status being processed, and the other spouse is the sole financial provider for the family, but at the same time is abusive. The women are then fearful of reporting or seeking help due to fear related to their own immigration status, for example, family separation or deportation, and related to fear of the family losing financial support. Aisha, primarily, and Rania, do you have a response to that question?
So thank you for that question. It's actually a really great question that I personally do encounter a lot in my practice as well. And I do see a lot of intersection between, family law cases and immigration law issues. And I think women that have precarious immigration status, and by that I mean either they don't have immigration status, they have temporary immigration status, or their immigration status is dependent on their abusive spouse, are left incredibly vulnerable, not only to further abuse, but they just face so many additional barriers in terms of accessing support. I think for a situation like this, if you don't practice, if you're a lawyer and you do not practice immigration law, I think it's really important to provide the client with appropriate referrals to an immigration lawyer. There are a couple of immigration applications and pathways to temporary or permanent residency that might be available to that client. So for example, there is the client might have the option of applying for application for permanent residence on the basis of humanitarian and compassionate grounds. There's also a new temporary resident permit application that immigration released, I believe in June of 2019, which is specifically for victims of family violence. So that application is specifically for cases where a woman is experiencing abuse and her immigration status is contingent on the abusive partner, either in the form of a sponsorship application or another form of contingency. So those are just two off the top of my head that I can think of, but I definitely think you should refer your client to a immigration lawyer to get further legal advice.
Thank you.
Thank you, Rania. Aisha, do you have anything to add, or should we go to the next question?
No, I was going to say the same thing, that whenever I have questions related to immigration, I tend to refer my clients to make sure that they get proper legal advice in that area of law.
Okay, thank you very much to the both of you. Our next question is a two-part question from Ewa. So Ewa spoke about CCMW's booklets. I have links attached in the Q&A portion or feature to take a look at, and they noted that it is only in French and English currently. You are absolutely correct. We have applied for funding, and Nazhat, you can speak on this if you like. And one of our priorities is aiming to have these booklets translated in other languages. You also wrote, Ewa, that you can arrange for interpreters, but that it would be helpful to have these in different languages, and we are working on that.
Yes, yeah, I was just going to say that we did apply for funds to have them translated. We were turned down because it was because it's not a cheap enterprise. It's quite expensive to do. So we'll continue. We'll say, we heard it again from participants at this seminar that the booklets need to be available, or the information needs to be available in other languages. So thank you for making our case for us.
Thank you very much, Nazhat. We have one from an anonymous attendee who states that there is case law, specifically Isa versus Said, that recognizes the Islamic nikah as being married for property division when the parties carry themselves out as being married and living together. Just like a Canadian legal marriage, if the parties had an intention to get legally married but did not for whatever reason. How often do you come across situations like this where the nikah is upheld for property division and spousal support? Or any thoughts on this case or this issue?
Interesting.
Again, to Aisha and Ghania, if you have anything to add or answer in response.
I would just like to add that in my practice, when I've had a client in that situation, I would try to see if an equitable remedy would be possible too. So let's say the client was contributing to the house and making payments, or paying the mortgage, paying the bills.
Sorry.
I would ask
sorry,
those questions as well.
Yeah, Aisha, you were cutting out quite a bit. Sorry.
Sorry about that. I'm not sure why, but I was just saying that I would ask the right questions to see if there could be possible equitable arguments made for the client where they were contributing to the mortgage, or they were contributing to the household expenses. I would ask questions in relation to that. I haven't had any in particular where I've had to argue the validity of it for the purposes of property. But one way I have gotten around that is by seeking an equitable remedy from the court.
Thank you.
Thank you very much. Ghania, do you have anything to add, or would you like me to go to the next question?
I think Aisha covered it.
Okay. Thank you very much. So the next question reads, in regards to meher, how should it be written down in order for it to be honored if the couple decides to divorce? Simply writing down the number doesn't necessarily mean they will receive it. And I think Dr. Timothy and Aisha and Ghania, you all touched on this and how it can be worked out as a disservice for the woman when it comes to a divorce. So does anyone want to speak on that?
Well, I can just begin. Certainly the legally trained people in the room can speak to how it should be optimally worded and written. But I think what's important for me is just clarity. I think I always tell couples when they're going into marriage that this is the most difficult thing you'll ever do. And of course, nobody ever thinks that marriage is, but it's so critically important that things be clearly stated, and especially now, even though the written document is not a legal requirement in Islamic law, it is just such an important document, if that's the only document that a couple has. And so I think in this situation, I think what's really important is just clarity. And the mahar is promised regardless of how the marriage ends, with the one exception of a woman seeking divorce with no cause. And so in almost all of these cases, cause is quite evident. And so what I just encourage couples to do is just to be very clear about what the mahar is. And it's not always a number. It's not always in cash payment or a financial transfer, but whatever the mahar is, I think it's really important that it be discussed and that it be clearly stated on the document.
Thank you very much, Dr. Timothy. Aisha, Ghania, do you have anything to add to this?
I think we did touch on this during the panel, but obviously, like in order for that provision or even for the contract to be valid and enforceable, it has to meet the formal requirements of contract law. And there's also the legislation, the Family Law Act, does provide some guidance on in which circumstances would make a domestic contract unenforceable, or what circumstances would allow a court to set aside certain provisions in a domestic contract. And I believe that's section 56 sub 4 of the Family Law Act. So I would definitely review that. And then I think one of the things that's important, I think, is also the language in which the contract or the provisions are written in. And if it's written in a language that one of the parties cannot understand, I think that's going to be an issue. There was actually a case in 2011, which is called Yar v. Yar. That's YAR. And in that situation, I mean, there was a lot of reasons why the mahar had been not enforced and set aside by the court, but one of the reasons was that it was written in Arabic and neither of the parties could speak Arabic or read Arabic. So I think that that's just one of the considerations apart from what we've mentioned today.
Thank you very much, Ghania. I'm going to pick and choose some questions now, only because time is limited. This question reads, do you have any recommendations on how to help a client who has left an abusive marriage, but does not want to explain the nature of the abuse for fear of the ex-husband contacting extended family members or other cultural pressures? Ghania, you are in the spotlight, so you may want to answer this question.
So I think the question is what is the client seeking? Is the client seeking legal services? Like, are they seeking like family law services? Because in that case, having some information about what the abuse was is relevant to the family law matter. And the recent amendments to the Divorce Act, which I don't think we had a chance to get into, actually are really great in that they do include a very comprehensive definition of family violence, and they talk about how that the court has to look at family law violence when considering what's in the best interest of the child. And there is a whole list of criteria that the Divorce Act has introduced for courts to look at when assessing impact of family violence on spouses and children. So for example, what is the nature and frequency of incidents? Was a child directly exposed to the violence or indirectly exposed? Or did they witness their mom being abused, or did the child themselves face the risk of harm? So that there is, I think it's really important, to explain to the client legally, like why it's relevant. And at the same time, it's a really challenging situation where a client is really unwilling or unable to share information about their abuse. And I think part of it, I think you have to identify what the reason is, because part of it can be like a trust building issue. And so I think it takes time working with the client, because for women that have experienced abuse, the person that they trusted the most has violated their trust. So for someone like that, it's really, really difficult for them to trust a third party, especially a legal professional who is in a position of power in terms of the legal system compared to they are. So it might be a process of building trust. There actually might be one of the impacts of the trauma of the abuse might be that they have developed some mental health issues that are actually inhibiting their ability to share information with you. So for example, I've had clients that I've worked with that have been diagnosed with severe chronic PTSD and depression disorder, and part of the trauma symptom is memory loss. Part of the trauma symptom is inability to speak about about, you know, the instance of the trauma. So I think in that case, you have to kind of collaborate and work with a mental health professional to kind of get that, you know, adequate support that the client needs before they can be, you know, ready to share their story with you. So it is complicated. It's on a case-by-case basis, and it is really challenging. But I think the crux of trauma-informed lawyering is, you know, the idea that you have to, as a lawyer, adjust your practice based on each individual client's needs. And each woman that has experienced abuse will have a different trauma response, and it might manifest, that trauma response will manifest differently. Some clients are, you know, they become, you know, closed off, dissociate, emotionally distant, repressive. And other clients, you know, will call you 5 times a day. They'll send you like 20 emails in an hour. Like it's just really different. So it kind of depends on what's happening. But, you know, you as a lawyer, you do have part of what you pay for when you buy this really expensive law degree is access to legal resources and this community and network of lawyers. So I would definitely say, you know, reach out to the Barbra Schlifer Clinic. If you want support, reach out to your colleagues to get further support on individual client matters.
Okay, I'm just doing a time check. We have 6 minutes left and we have many more questions. So we might go slightly over. If you have to go right away, just flag it for us and we'll keep that in mind. Sabrine, go ahead, please.
Yes, thank you, Nazhat. So I'm going to merge 2 questions. So one says, is the meher considered a debt from the husband to wife at the date of marriage and separation? And the other says, similarly, if I understand correctly, meher is added as a debt on the husband's net family property calculation. Doesn't that result in reducing the husband's assets? So I think this is more for Aisha or Ghania, if you'd like to take this on.
The case that I gave was an example where the judge excluded it from the net from family property because it undermined the intentions that the parties had when they were making the contract or the marriage contract. And so I think like I wouldn't count it as that. I wouldn't put it down like that on the marriage on the financial statement. I would put it as money owed to the client. As a, yeah.
And I think this touches on something that we talked about, how you have to define it's prudent to define what meher is and what the purpose of that is in the actual marriage contract, so that it is distinct from, you know, other claims like spousal support and, you know, equalization. And, you know, if the meher involves, as I mentioned, if the meher involves interest in or ownership shares in the matrimonial home, remember that is dealt separately when it comes to that has a special status when it comes to equalization. So if the meher involves getting a portion of a share of that, then it's you have to kind of be you know, devise a marriage contract that way, so the client still gets to benefit from the meher without it being included in the net family property.
Thank you. So this adds on to it, but essentially this person is asking how you disclose the meher in the client's financial statements. And I think, Aisha, you just answered that.
Yeah, I also want to add that it really depends on like the specific case before you. If they have other property, right? If they don't have any other property, there's no matrimonial home. Then I'm not really treating it the same way as property then. Sometimes what I would do is I would use it as a negotiating tool for spousal support, because spousal support is something that, like, you know, could be paid out as a lump sum. So maybe I would add it to that, right? So I don't always treat it as property. I don't always treat it as money. I don't always treat it as money owed in characterized like that. I think it's important to, depending on the situation, depending on the client, to look at their financial picture as a whole. But it's just important to ask those questions. I think that's the main takeaway for some of the lawyers on here. When you're trying to figure out how am I going to be able to make this meher enforceable. what can I do, right? So just being creative. Sometimes I use it, and I have characterized it as a spousal support lump sum payment in addition to the spousal support that would have been owed under Canadian law.
Thank you
I
very
hope that
much.
answers the question.
Thank you, Aisha. So this question is for Rania. So this question asks, how is your client going to know their options if they don't know their women's rights in Canada? Do you feel you may be undermining women who are stuck in polygamous marriages in Canada?
Sorry, Sabrina, could you repeat the question?
Yes, for sure. So the question reads, how is your client going to know their options if they don't know their women's rights in Canada? Do you feel you may be undermining women who are stuck in polygamous marriages in Canada?
I mean, in terms of, we talked about lack of women's knowledge about their rights as a barrier to access to justice. And I think it's responsibility of the, in the institutions that are involved in this justice or legal system to, reach out, provide resources so that Muslim women that are seeking help can find that, can find that appropriate, referral and the appropriate counsel for them.
Thank you very much, Rania. So one question is by Esma, who says salam and thank you. She is asking if we can do a presentation for imams in Ottawa. Most definitely that is feasible. Esma, please send me an email and we can work on that offline. So thank you. One person said a program to convert a sponsorship into a H&C for abused spouses. Anybody want to touch on that?
I think that's a response to an earlier question about pathways for women who have precarious immigration status and who are financially dependent on their abusive spouses. So one of the options that they have is they can have their existing sponsorship application be converted into a different type of application for permanent residence, which is based on humanitarian and compassionate grounds.
Okay, thank you very much. So the time is actually 3 o'clock and it looks like I don't see any questions in the chat box or in the Q&A feature, and I'm looking through the chat box. Nazha, do you see any, or if anybody has any last minute questions, please do share them.
So I noticed that there were some really great comments. People were sharing their ideas, and I mean, we could literally do another session because there were so many things that we didn't cover. And we are going to have a session for community service providers, but we will focus on a number of things that you all touched on already, but that have to do with services for the women that go beyond the legal system, like counseling and other kinds of supports, but also what the legal provisions are for those kinds of supports. So we'll be talking about that next week. I think you covered most of the questions. I don't.
Yeah, I think.
Yeah. So one thing about the mahar, I mean, I've heard or I've seen it being described as a gift, and that it is, it is actually given to the bride at the time of marriage. It's usually part of a contract. It's written in, the amount is written in, but because, as Timothy said, it's not always written down, but the value of writing it down and specifying it the way that Aisha was describing it is immense, because if you're going to have a marriage contract that's going to be treated as a contract, all the provisions really do need to be spelled out so that there aren't any disputes later on about what the wife is eligible for at dissolution of the marriage. And in fact, many marriage contracts specify what will be paid up front, what will be deferred, or the full amount will be paid, at the dissolution of a marriage, or any time. She could actually access her gift, if that's how it's characterized, as far as I know. Because there is no provision, and Timothy, correct me if I'm wrong, that it does not say that you will get this amount if the marriage dissolves. It does not say that, or it's not a requirement.
No, not typically. Again, the mahar can be whatever the couple wants, but of course there needs to be coaching involved in formulating what that mahar is. And so the imam or the religious advisor or the families can be very instrumental in helping to shape and guide the process of conceiving and articulating the mahar. And so I think that that Barbara's point about making sure that both husband and wife, or both bride and groom, are well equipped with information about their rights going into this under Canadian law. That certainly is important for marriages that are being contracted in Canada now. But of course, many of these cases involve marriages that happen in other cultural environments and in other countries. And so this is a great way to think about going forward in a better way. But that's right. So the mahar itself can be articulated however the couple and the imam and the families want it to be articulated. And so that's an important thing.
And this is back to what you were saying about gifts, characterizing it as a gift. If there are other gifts given during the marriage, that would be a good idea to characterize those as well. Specifically, if there's jewelry being given, that could be outlined there as well, so that it's more complete, right? We're not just talking about the meher and then come separation, the wife is like, well, I was given all this jewelry, and now he's arguing that no, it was never a gift to begin with. So then you have the meher, which is a gift, and then the jewelry, which is not mentioned. It just brings some ambiguity to the contract. So if there are other gifts, and if you're going to characterize the meher as a gift, then outline those and make those very clear.
And I think it's also very important as we counsel couples going into this, the mahar does not entitle the groom to anything, right? So it means that it's not what he gives in exchange for a lifetime of consent. It's not what he gives. So there's no entitlement other than marriage itself. And so it's very important to make that very clear as well to couples going in, because very often, again, it's something that comes up often in these abusive situations, is that consent is given on the wedding day, and he paid for it with the mahar, and so these misconceptions need to be really clearly dispelled before the couple enters into a marriage.
Absolutely.
I just see one last question, if possible. It's from Tahir, who said, I just want to make sure, is the meher added as a debt owed by the husband on his net family property financial statement and added as a debt to be paid to her in the financial property statement? Because they are trying to understand how meher is entered for each spouse on the NFP statement. So it seems like there's a lot of concern about this. Aisha, did you want to go ahead?
Yeah, you know what? I want to qualify what I said before. I think it's really important that this not be used as a way to give specific legal advice, because I wouldn't be comfortable answering that question until I understood the person's financial picture, because to determine the net family property, you would take each spouse's assets minus their liabilities, and then the difference between that number would be the number to determine their net family property. And I think it's a good idea to. I don't know if I could really say that right now. I don't think I could say that without looking at the person's financial picture to see, because my goal would be to enforce it somehow. So I don't know what other debt this person would have or whatnot, and I'm not sure if I would do that. I don't feel comfortable answering that question without knowing the specifics of a particular case.
That is very fair. Thank you, Aisha. We do another lawyer in the chat box. So Najia said, also when jewelry is given by family, have it in writing that it is a gift from that person to the bride. So thank you for that. Are we okay with closing up the Q&A for now, as of now?
I think we should. I know that we're over time by 7 minutes, so we apologize, but the discussion was really rich, and I really appreciate, Sabrine, thank you for facilitating the Q&A from our participants. And of course, Aisha, Rania, and Timothy for your participation, your wisdom, your experience, sharing it with all of us. And Barbara, thank you for telling us about the hubs. I know that's a very important initiative and alternative. So some of you have said, this was very useful, this was very helpful. So we did record the session and we'll make it available on our website. But if you want to do this, locally, and you want to assemble either the same, I won't commit to the same panel just because they've given us generously of their time. But maybe we could have something very similar. I also want to tell you that if you haven't seen our resources on our website, especially the booklets that you may want to hand over to your clients, they're downloadable. We apologize, they're only available in English and French, but we're working on trying to get money to do this in both languages. And before I go, I had actually prepared something for myself because of where I am located. So in closing, I'm going to share it with you. But again, I'd like to thank you all for being here. And until next time, we have a community one coming up next week. You're welcome to join that one too, because the content and the emphasis might be slightly different, but our experts will be the same. So we're grateful for that. Thank you so much. So before I go, I do want to tell you that the place where I'm talking to you from is the traditional territories of the peoples of Turtle Island. The sacred land on which I share this space with you has been a site of human activity for 15,000 years. This land is a territory of the Huron-Wendat and the Petun First Nations, the Seneca, and most recently the Mississaugas of the Credit River. The territory was a subject of the Dish with One Spoon Wampum Belt Covenant, an agreement between the Haudenosaunee Confederacy and the Ojibwe and allied nations to peaceably share and care for the resources around the Great Lakes. Today, the meeting place of Toronto is still the home to many Indigenous peoples from across Turtle Island. As a Canadian Muslim woman, I must recognize the connection between anti-Indigenous racism and sexism and gendered Islamophobia. And I'm committed to working toward justice for Indigenous women and girls with all of you. So thank you again for being here. And we'll see you again next week. Some of you anyway. Okay. Have a great afternoon.
Apologies. I do want to just add that an evaluation link will be sent out to each of you, and all the information that we have shared in the chat box will also be sent to you. And any lawyers here who would like to join CCMW's Family Law Legal Resource roster, please shoot me an email or a text message. So thank you again to Aisha, Rania, Dr. Timothy, Dr. Barbara, and of course, our excellent moderator, Nazhat Jaffrey.
Thank you so much.
Well,
Thank you.
bye-bye. Thanks.